around in a car. So the state is arguing that the injuries occurred earlier and the torture, the child abuse, was riding that child around in the car. On appeal, the state is trying to raise a completely different argument. The state is trying to now argue on appeal that my client is the one that inflicted the injuries based on some circumstantial evidence test. I think there's two problems with that. Number one, I don't think the state can present a theory for the first time on appeal that's completely contrary to what was presented to the jury. Number two, and I know the court is aware of this, but this is a difficult case from the standpoint that we're dealing with both Alabama and Florida. And I think the prosecutor below was very careful to make sure that everything that was the focus of her argument as to why my client was guilty was based on acts that occurred in Florida. And the undisputed evidence in this record is that this child was injured either Sunday evening or early Monday morning by the mother. The mother testified and acknowledged the child was injured but didn't say how the injury occurred. My client specifically said in the statements to the police that the mother is the one that hit the child in the groin. He did not hit the child. And then just as importantly, if not most importantly, a law enforcement officer testified that he in fact talked to the mother and the mother admitted striking the child on multiple occasions. So the theory is the theory that the state focused on, and that's what I'd like to argue this afternoon, that although the state also charged my client with child neglect, and my client is serving a 15-year sentence for that offense, and the state charged my client with leaving this child unattended, and my client is serving a consecutive 5-year sentence for that, so a 20-year sentence for those two counts, they've also charged him with child abuse, for which my client is serving a 25-year sentence based on the act of failing to provide medical care, an omission. And as I've argued in my briefs, in 1995, that may have been that would have been a valid theory. The statute that the legislature adopted specifically said in 82701, the definition section, that torture includes an act, omission, or neglect. But the legislature amended that statute in 1996, as acknowledged by the Cox case from the 2nd DCA.
What's the ordinary definition of torture now?
If you look it up under Merriam-Webster's dictionary, it simply says to inflict pain. And I submit that inflicting pain is an act of commission, not an act of omission.
Well, that's reading that in there. It could be either way, couldn't it? If inflicting pain is by an affirmative act or a failure to act, what does it matter?
I don't think that failing to provide medical care inflicts pain, Your Honor.
Well, I have to disagree with you on that. I think certainly if someone's in a position to provide care and withholds it, and the person gets into excruciating pain, that could be deemed torture or tortuous.
I think that's neglect. I don't think that's torture. I think you have to then, let's define inflict. Inflict, under Webster's dictionary, is to give, by, as, or by striking. Infliction itself talks about an act of commission, not an act of omission. And again, the definition of torture is inflicting pain. The Wheeler case that I've cited, that out of the 4th DCA, also is a recent case that talks about what torture involves. And the 4th DCA said that torture involves extreme or sadistic conduct. Again, when you define sadistic, the definition is inflicting pain. Both the Wheeler case and the Cox case have looked to other cases where DCAs have affirmed convictions for aggravated child abuse. They almost always, if not always,
I'm having a disconnect, because if I fail to give my child food, fail to give my child water, I'm not acting. I'm just failing to perform a response.
That's child neglect.
Okay, well, that could be, but isn't it also perhaps a form of torture?
I don't think so, Your Honor. It's not, and I think you have to look at, and I hope this court does this, look at the existence of Chapter 827 prior to the 96 change and after the 96 change. Prior to the 96 change, child neglect was its own separate statute. It was 82705, and child neglect was a second-degree misdemeanor. When the legislative history demonstrates that when the legislature changed 827 in 1996, they substantially revised the ideas of child abuse and child neglect. They beefed up child neglect to now be a third-degree felony and actually can be a second-degree felony if great bodily harm is involved. Again, my client's been convicted of child neglect for this conduct, but it's simply not, and again, most importantly, and I should have said this earlier, the legislature took out the definition of torture from the statute, from 827. And this court said in the asphalt case, asphalt pavers, and let me quote it, I apologize.
it meant it to be something different, and why could it be something broader than what was there before?
Well, it is recognized principle of statutory construction that when the legislature amends a statute by omitting or including words, it is presumed that the legislature intended the statute to have a different meaning. So at the time, we know from this court, the Nicholson case that went up to the Florida Supreme Court, and the Florida Supreme Court affirmed that torture did involve the act of omission or the failure to provide care or neglectfulness. The legislature took that out, and I submit that therefore torture has to have a different meaning. And in doing so, they took it out and beefed up what amounts to child neglect. Changed it from a second-degree misdemeanor to either a third-degree felony or a second-degree felony. And I submit the only way that you can apply that principle of statutory construction when the legislature takes out the language of omission being under the definition of torture is that now, moving forward, torture involves an act of commission, an actual infliction of the injury by an act, and child neglect involves the failure to provide medical care. And that's what we have here.
That's a lot of steps there. I mean, they could have just amended the definition of torture, right? I mean, when you take one away, back to Judge Makar's question, it just means it's not going to be limited to that anymore.
I don't think it was limited to anything. It was as expansive as it could possibly be. They did so right after the Florida Supreme Court approved this court's opinion in Nicholson to say that torture could involve both acts of omission and acts of commission. And then so shortly, within a year after the Florida Supreme Court decided or approved this court's opinion, they take that language out of this statute. If you look at other statutes, I think this court's recently had a case on animal cruelty where the legislature specifically defined torture to include failure to provide care. We don't have that under 827. We have a regime where if you torture a child, that amounts to aggravated child abuse, but if you fail to provide care, that amounts to child neglect, and it can be aggravated based on great bodily harm, up to a second-degree felony. In this case, again, my client's been convicted of the child neglect, but how is him simply, well, and the other thing is, the Wheeler case said that torture is limited to the extreme case. And the examples that are cited in both Wheeler and Cox involve extensive, one was videotaped beatings with a baseball bat and a paddle. Another one involved extensive, numerous beatings over a long period of time. So torture has to be limited to those extreme cases, which again, I would certainly acknowledge beating a child over a long period of time with a baseball bat falls into extreme or sadistic conduct. Driving a child around who may be injured over a period of one day, you know, I'll address count 4 in a second, but over this particular count, which is only for count 2, it's only September 16th, that Wednesday, that does not amount to extreme or sadistic conduct. It can amount to child neglect. He failed to provide medical care. But how does that possibly rise to the level of the extreme or sadistic case when you look at the other cases that have upheld torture for child abuse and they involve those types of beatings?
Well, the child's injuries here seem to be pretty severe, wouldn't you say?
Of course, the child has significant injuries. I'm not disputing that. I have not disputed that in the brief. I've made a claim that, citing the Posnatech case, that the state perhaps failed to provide a link that my client's failure to act added to the great bodily harm that didn't already exist as a result of the mother's beating. So I think there is an argument about whether or not it amounts to great bodily harm causation for my client, but I'm not going to sit here and argue that the injuries that this child had weren't significant, but simply driving the child around for a period of several hours in the morning doesn't rise to the extreme or sadistic level, which is what torture has been defined as, to make this a child abuse torture case as opposed to a mere child neglect case. And again,
You said what it's been defined as. Where are you drawing your definition from torture?
So I think we know under Florida law,
Case law you're talking about.
when there is no definition provided by the legislature, which there is not now, there is no standard jury instruction, you have to give a word its plain and ordinary meaning. So if you look up torture.
Wasn't that inconsistent with your argument that by removing the definition, the legislature meant to narrow it?
I think they meant to narrow it. That's what I'm saying. I'm sorry I didn't hear your question.
Well, yeah, you read us the quote about the legislature obviously means to change something when
Yes.
they change something. But then there's the other rule that says when there's no definition provided, you go with the dictionary definition. So why wouldn't our read on what the legislature did was substitute a statutory definition with a dictionary definition?
Because I don't think, well, so if it has to be different than what it was, and what it was
That's your argument, right?
Yes.
Okay.
And what it was an act, an omission, or neglect, that pretty much covers everything. So if it already encompassed everything, and now it's different, the only way to go is it's limited. Does that make sense?
But when there's there's no definition, I thought you said we go with what the ordinary plain meaning would be.
Well, I think you have to obviously apply both of those concepts. So we do know generally under the law for any type of word that's not been defined by the legislature that the court case law says that a jury is required to give that term its plain and ordinary language. But when we're deciding what falls within the province of torture after the legislature amended the statute to take out that definition, I submit it can't be more expansive than what it was, so it has to go in the direction of now being limited. The way you would limit it is clearly you have access. And again, that was the whole issue in the Nicholson case. I don't know why it was a very strong issue, because the statute at the time defined torture as including an act of omission. It was pretty easy for this court to reach the conclusion that, no, you're wrong, appellant, omission falls within the definition of torture. But when the legislature, a year later, after that case is finally resolved, says we're going to take out that definition, and we presume that it has a different meaning, the only different meaning it can possibly have is we're going back to it means commission as opposed to just omission.
Well, that's focusing on the action, the verb, but also that statute said whereby unnecessary or unjustifiable pain or suffering is caused. So perhaps they were changing the pain threshold standard versus the conduct standard.
But they could have then kept that language and simply added in the pain threshold, and that would support that argument by not doing so and taking out the omission and neglect language completely, and then beefing up what it meant to amount to child neglect when they made the 96 changes. And if you look at the legislative history, they said that one of the purposes was to substantially rewrite what it means to amount to child neglect. I submit that it leans in my favor that the legislature intended to move in the direction of going away from the all-expansive and inclusive definition of torture. Let me kind of pivot then to issue number 3, because I think it's related to this. At the very least, we have the prosecution reading to the jury a definition that is not accurate under current Florida law. And the way this was read to the jury was as if it was, in fact, the definition. And I think it was read twice by the prosecutor. So the state has argued initially on appeal that that's not preserved, and I've argued that this occurred at the very end of the prosecution's argument. It's only a couple pages later that as soon as the prosecution was done, or the prosecutor was done, that the defense attorney said, I need to go to sidebar, I need to get a curative instruction to tell the jury, no, it's not what the state just said. You need to give this term, torture, its plain and ordinary meaning. The judge just declined to give that curative instruction, saying, I don't think the jury was misled. I've argued in my briefs there's no way you could say the jury would not be misled. If one juror heard that and believed that that's the definition of torture under Florida law, when it's not, the definition under Florida law has to be give torture its plain and ordinary meaning, because it has not been defined by the legislature. That's extremely misleading, and if that's why my client got convicted for this count, then that requires reversal at the very least for a new trial.
On the issue of the photograph of guns, there was evidence that came in without objection and that you've not challenged in your brief that there were guns on the floorboard. So the jury, with or without these photos, would have known that there were guns on the floorboard. And my question is, how would that not make the introduction of the photographs harmless error if it were error?
I believe the defense counsel's argument was meant to prevent any mention of guns in this case. And the state's response to that is not that it was relevant to the crimes as charged. The state's response is it was relevant to a lesser offense. They haven't cited, and I haven't found a single case that says you can introduce evidence that otherwise would not be relevant to the crimes charged if it's relevant to what may be a lesser offense in the case.
No. But so your position is there's no evidence that went before the jury about guns without an objection attaching to it? I'd have to look back, but that's not my recollection.
My position is, and I need to double check it, is defense counsel's argument when this came up was, Judge, I want to prevent the state from going into any evidence about guns. And when the judge overruled that and said, I'm going to let the state introduce the evidence, I think from that point forward, the evidence came in, but it was at least assumed. Perhaps defense counsel could have objected at some other point, and he didn't, and I'm not aware of that. I need to look at the record. But I think initially he preserved the argument by saying up front, look, I don't think evidence about the gun bag is relevant. The state seemed to concede it doesn't go to the crime charged. It goes only to a potential lesser offense, and I don't see how that would ever be a valid basis to allow otherwise inadmissible and prejudicial evidence to come in.
And in your position is it would not go to the neglect charge at all?
It would not. If I could have a moment to explain that. I see.
Go ahead. Take your time.
Thank you. The charge for the neglect charge.
Well, I'll try and be consistent. I'll give you 3 minutes more like I did in the prior case.
Thank you very much. The information alleged for neglect, actually I wanted to do it from the transcript. To prove the crime of child neglect causing great bodily harm, that must prove the following. Mr. Hicks willfully or by culpable negligence failed or omitted to provide the child with care, supervision, and services, and in doing so, that caused great bodily harm to the child. As charged, it's clear the state's theory is that this child was injured, he failed to provide medical care, and the child suffered great bodily harm as a result of that. That has nothing to do with a gun bag that, as defense counsel argued, there's no evidence that the child was even aware was in the car. Now, had he injured himself, or had there been evidence perhaps that he was playing with the gun, there might be a different situation, but this is a gun bag in the car, no evidence that the child is aware of it. It's not the theory for this child neglect charge. It would only go to the lesser offense, which if you read right, this is page 321, Your Honor. Neglect, it's the lesser crime. To prove the crime of neglect of the child, the state must prove the following well, it goes on to explain that for the lesser offense, it's not that the child was actually harmed, but the child could have been harmed. And for that theory, I guess the state's argument could be that had he grabbed the gun, he could have harmed himself. I get that. That's not the theory that's the basis for this particular count, count 2. The theory is clearly that he's injured and he's failing to provide medical care. Guns have nothing to do with that. It's extremely prejudicial for the jury to hear that there's also a bag of guns that happened to be there, even though there's no evidence that the child was even aware of that. If I may have, I guess, I have 1 minute left for rebuttal.
If you like.
Thank you. I appreciate that.
Good afternoon. May it please the court. Caitlin Weiss on behalf of the Office of the Attorney General for the state of Florida. Your Honors, the state asks that you affirm appellant's conviction and sentence. The first issue of this case is in the context of challenging the motion for judgment of acquittal. In a circumstantial evidence case on a JOA, all the state has to do is present legally sufficient evidence that is inconsistent with appellant's reasonable hypothesis of innocence. And that is precisely what was done in this case. Considering the evidence, the inferences from the evidence, and in the light most favorable to the state, appellant's hypothesis of innocence was not reasonable, and the state put forth 2 theories with sufficient evidence to support those theories to justify the denial. Now, counsel argues that the state cannot and did not argue that appellant caused the injuries below, and I very strongly disagree with that. Appellant was charged in count 1 of the information in the alternative. He was charged with the causation of the injuries or the willful torture of the child. If you look to the record, the state argued both theories throughout the trial. During JOA, Volume 6, page 266, the state argued causation. During the cross of appellant, they crossed him on causation. That's on page 285. And they argued causation in closing. They argued both. They charged him with both. He was on notice that he was charged both with the causation or if he didn't cause the injuries with the willful torture of the child by not treating the injuries and by making the choice to put him in his car while injured to that extent and drive to Florida.
What about on count 4, what is the state's evidence that he did something within the jurisdiction that on the 14th, or the earlier day, I think it was the 14th?
Yes, you're correct, Your Honor, it was the 14th. So on that count, he was found guilty of the lesser of culpable negligence exposing another to injury. That's from September 14th. And the testimony on that day, the child's mother testified that early that morning or the evening before the child had been injured. But her testimony was that that morning when she put him in the car alone with appellant, that he was fine. She even testified directly that he was walking. And then her testimony was that when he returned home from a day in Florida with appellant, which appellant acknowledged.
In Florida and Alabama, right? I mean, that's my question is, so the evidence is he leaves the home in Alabama okay. He comes back from the home to the home in Alabama not okay.
Yes.
And so the inference is in between the defendant harmed him, or was, in this case, negligent in a way that led to his harm. But how do we know where that happened?
Well, I think you have the testimony from the appellant acknowledging that they spent that day in Florida, that he tried to go to court. I believe it was a judge's holiday or something. He was told he couldn't handle his matter in front of the court. His testimony was that they went to McDonald's and played at the beach. But obviously, something else happened. And I think that, again, under judgment of acquittal standards, where we're looking at the evidence in the light most favorable to the state, it could be found that a child who leaves home in the morning, is alone with the appellant all day, and comes back injured to the point where the mother felt that he needed medical attention, that something has happened in that period that justifies a
But
survival.
the totality of that evidence, other than the defendant's testimony, which would have come after the motion, I guess, was that the mother's testimony that he left okay and came back not okay?
Yes.
That's the totality of what the judge should have been looking at for the JOA as to count 4?
That and that they spent the day in Florida, yes. The child came back injured. The mother said that was the point where she felt like he needed medical attention. That was the point where the appellant began interfering and saying, no, we shouldn't let him see a doctor, shouldn't let him go to daycare, shouldn't let him go to your mother's house. So, yes, on that point. Going back, as I said, the state did raise the issue of causation. They raised it below. It was charged in the information. I think that's appropriate to consider. And I think that the state presented.
You're talking about count 1 now?
Yes, back to count 1. The state presented perfectly sufficient evidence to justify a denial of judgment of acquittal for causation based on the mother's testimony that the child was not injured until he was alone with appellant. I did supplement the record with the Rivet case, which was released by this court last week. Similar facts. 2 people, very specific allegations that the other party committed the crime against the child. And that's what we have here. Appellant has never alleged that there was a third party or anybody else involved. The denial of the other party is sufficient to survive a motion for judgment of acquittal. And in this case, the mother's testimony that while the child was injured Sunday night or Monday morning, he was fine on Monday, and the injuries only began after being alone with appellant, I think is sufficient to justify denial under causation. Now, as to torture, appellant cites Asphalt Pavers versus Department of Revenue, and he cites a line from that case. The next line after the line that he cites in that case says, a mere change in the language of a statute does not necessarily indicate an intent to change the law. And I agree with the point that when you remove a definition, you are left then with an understanding that you look to the plain meaning of the language. And in this case, the plain meaning of torture does not mean that it can't be neglect or it can't be an act of omission. You're just looking at the plain meaning of the statute. And so, as to the issue of proof on count 1 and the statement of the prosecutor on count 2, there's no error in stating that it's possibly an act of neglect or omission. What we're left with is simply the word torture in the statute, which can then be given its plain and ordinary meaning.
Well, he gives a pretty compelling argument that if you look at it in terms of Venn diagrams, the overall world of torture was covered by the previous statute. Everything's there. Now that definition's gone, it has to be something different. Doesn't it have to be, as a matter of logic, something smaller in terms of the conduct portion of it?
Why couldn't it be broader? Why couldn't their intent?
Well, his point, I'm sorry to interrupt, but his point is that the statute already covered everything. Looking at conduct, not the pain, suffering aspect of that. So if all conduct is covered broadly, it would have to move in the other direction, is his argument.
I disagree with that argument. I think that removing the definition simply puts you back in the rules of statutory construction, and that when you're in the realm of statutory construction, the obvious assumption is not that this is a narrowing. The obvious assumption is that this is just giving the word its plain meaning. It's fewer steps to reach that assumption than to assume that they're narrowing, like slashing the definition of the word by changing the language of the statute.
But the only definition that was given to the jury was, I guess they weren't given a definition, were they? They were just told by the prosecutor a couple times the language of the old statute.
So skipping ahead to address that to issue 3, the prosecutor said that once. It did not draw objection. The judge then gave the correct jury instruction. And again, it's the state's contention, first of all, that this is not preserved. Appellant notes that this happened within a few pages on the record, that the objection was made. But if you actually look at the record, The state finishes their argument. It's concluded. The state and defense begin to discuss a jury instruction. This is on volume 6, page 312. The court gives a recess for the parties to use the restroom. So there's one recess. The parties return. Then the jury is released to finish the jury instructions. The state says, I want to keep talking about a special instruction on torture. The judge gives a second recess for the parties to consider and do research on a definition of torture. After researching, then the parties come back, and then the defense objects. So this is not something that, oh, closing argument finished up, let me run up and try to put my objection on the record. There was some time between the finishing of the closing argument and the objection being made, and it was only after the parties were released, specifically for the purpose of researching the definition of torture, that an objection was entered. And so that is not preserved. And I'd be happy to supplement the record with a case that I found while preparing for this oral argument, Bright v. State, out of the Florida Supreme Court, 90 Southern 3rd 249.
Sounds like you just did. So.
Which has similar facts. I think that because there was such a long time and 2 recesses, this is not preserved. I think that even if it were preserved, though, the next thing the jury hears is the judge giving the proper instruction on torture. So there's no harm. The proper instruction was given. The state's closing argument was predicated by the judge, and I cite to this in my brief, saying that what the lawyers say is not evidence. So I see no error in this, first of all, because of the definition. This is not necessarily an incorrect definition, because it's not preserved, because the judge follows up with the proper jury instructions. If there were error, it's harmless.
On the gun photographs, is it your understanding that there was an objection to everything about guns, or just the photographs, or?
Judge, I would have to go back and check the record on that. To be honest, it was, just from skimming my brief on that, I believe it was just a general objection at the beginning to the photographs of the gun, coming in, but I'm not sure of the specifics of that. I will point out, though, that as to that issue, I did argue in my brief on page 29 that it was relevant to the crimes that appellant was charged with, which was the child neglect, that it did go both to showing that leaving the child in the car constituted neglect, and then to proving the lesser included offenses of that count. And so,
Well, how do you respond to his argument about the neglect being charged as not providing care, food, things like that?
So I think the count that this is relevant to is count 2, September 16th, the day of the arrest. The charging document is failing or omitting to provide the victim, a child, with the care, supervision, and services necessary to maintain the child's physical and mental health, including but not limited to food, nutrition, clothing, shelter, supervision, medicine, and medical services. I think you could easily argue that leaving a 4-year-old in a car with a bag of guns is not providing supervision.
Right, but then he made the argument about the harm and having to tie those two things together. I mean, certainly you leave him and he comes back with a medical problem, that you tie those together. Here, the gun, fortunately, I guess, wasn't tied to whatever physical harm that he had.
I agree.
What's your response to that argument?
I agree that the guns did not cause the harm to the child. I think there's no dispute that that didn't happen. But I think that if you believe appellant's hypothesis of innocence, that he didn't know that the child was injured, he had no idea that the child was in pain or harmed, and he left him in the car to go to court with Gatorade, which was not found, with the windows rolled down, which were found rolled up, that, you know, showing that there's guns in the car goes to show still an act of child neglect. So again, it's a question.
But he was charged with the act of child neglect that resulted in great bodily harm.
Yes.
I mean, I don't think anyone would say it's not neglectful to leave a child in the car with loaded guns, but the question here is how do you tie that to the harm? And that was his argument. I'm just saying it doesn't have to be tied, or
I don't think that you can tie the guns to the harm. I can't make the argument that you can, but I think that you can tie it to overall proof that the situation that he left the child in is neglect, and I think that it is then directly on point for the Category 1 lessers, which do not include the proof of great bodily harm. So I think that when you come to the Category 1 lessers, which defense counsel did not object to keeping as part, of the trial, that it becomes directly on point for those counts.
Was it argued at all? In closing argument, did the prosecutor say anything about the guns?
The prosecutor did not mention the guns in her opening or her closing.
So how would the jury know? How would the jury know that the guns had some relevance to their deliberations?
They were discussed in testimony with the relevant witnesses.
Right.
And I believe that on this count specifically, the prosecutor crossed the appellant about the wisdom of leaving a child in the car with a bag of guns in a way that I think, could be read into the neglect. But I'd like to end my time by briefly addressing the argument that taking the injured child in the car was torture. Torture, I think, is proven here, and this is the state's second theory that they operated under, proven to survive a JOA. The mother's testimony was that she told appellant that the child was in pain. There was medical evidence that the child would have been in excruciating pain from this injury. There was evidence from the first responders that the injuries were visible, not just the injuries to the groin, but that he had bleeding lacerations to his face and was covered in bruises. There was evidence from the child's stepmother that putting him in the car after he had been hospitalized for several days caused him extreme pain. She testified that he was crying a lot on the way home, that he was very uncomfortable, that she could hear him crying on the phone as they brought him home from the hospital. So the appellant made a choice. He took an act to put a child that he must have known was grievously injured into his car and drive him in a way that the evidence showed caused him terrible pain. And that is sufficient to survive a motion for judgment of acquittal, and the state asks that you affirm.
I don't think you got your 3 extra minutes. You don't need to use them, but if you'd like more time, to be fair, you may have it.
If you have any questions, I'd be happy to answer them. Okay, well then I'll leave it on the table. Thank you.
Thank you.
May it please the court, regarding claim 3, this is what the prosecutor said to the jury. Torture is every act, omission, or neglect whereby unnecessary or unjustifiable pain or suffering is caused. That's what torture is. Every act, omission, or neglect, and she repeats it again. Anyone hearing that would think this is a definition she's reading from. She's not just giving her opinion of what she thinks the plain and ordinary meaning of torture is. The purpose of preservation is to give the judge a chance to correct the error. In this case, defense counsel said, I simply want a cautionary instruction that torture should be given its plain and ordinary meaning. The judge said, I don't think the jury was confused and refused to give what defense counsel requested. Judge was put on notice, had an opportunity to correct it. I respectfully disagree with opposing counsel. The judge didn't give any definition of torture because there is no definition of torture. The judge simply defined that aggravated child abuse can include torture. The jury is left to believe that torture must mean what the prosecutor said it was, and that's not the law. We know for certain the law is torture should be given its plain and ordinary meaning. It could be that, it could be the juror's different conclusion, but my client didn't get a fair trial because of that. I'd ask you to reverse. Thank you.
Thank you. Thank you both for your arguments. The court will be in recess.
All rise.